RMT has confirmed that it's launching an unprecedented challenge to the UK's anti-trade union laws in the European Court of Human Rights. Papers have been passed over to our solicitors and our standing counsel, John Hendy QC. RMT will argue on behalf of its members that its ability to organise industrial action to protect our members is restricted by UK law in a breach of Article 11 of the Euopean Convention on Human Rights and Fundamental Freedoms.
This is an application to the European Court of Human Rights, and what we're saying in this application is the United Kingdom law on strikes is in breach of Article 11 of the European Convention, and we're saying that that's demonstrated in the EDF case and in the Hydrex case. The EDF case because an injunction was granted against the strike on the basis that the union hadn't properly categorised the members who it was going to call out on strike, and the employer claimed it couldn't make proper preparations. We call them engineers stroke technicians because that's what how the union classifies them.
What we've seen in these cases that we're presenting to the courts is that an employer can basically turn around and say, we're going to break up a company, hive it off, and when those groups of workers who was working for the parent company before they was hived off try to defend themselves, then they're stopped from taking industrial action. And it defeats, and that's the reason why these companies want to break up all their companies into different subsidiaries, is because one company can't support another. On the question of the category of names, on the EDF situation, the Energy de France company, well, this makes a nonsense to it. I mean, surely democracy means that someone gets a ballot paper and they vote yes or no, and we respect the outcome of the ballot. What the matrix system's got to do with democracy is diabolical, and all it boils down to at the end of the day, it just puts hoops and hurdles in the way of workers having the opportunity to fight back. I mean, when they shut Jarvis, the company, down, Jarvis never sent us a matrix system and said that we're shutting this company down in 3 days' time. They never balloted the workforce to say, should we shut the factory down? When they reduce terms and conditions employers, they don't ask the members for consent in a ballot. And we think at the end of the day that all this is basically to do, and it's proven, it's bureaucracy to stop trade unions having the effectiveness to defend their members.
These laws have been here for nearly 30 years, and it's just that they're a weapon that employers can use, and as it happens over the last best part of a year, the employers have been picking up those weapons and using them against unions. And what we're seeing in the recent cases is just how strong those legal weapons are to defeat trade union democracy, really.
It's a human right in our belief to withdraw one's labour, and there shouldn't be all these restrictions put in place to stop workers fighting back.
If the European Court of Human Rights were to hold that these limitations on the right to strike were in breach of Article 11 of the European Convention, then the government, whoever they happen to be at the time, would have to change the law to comply.
And this legislation, by the way, is about the employer being able to convince the workers not to vote in strike action. Well, they can do that anyway. I mean, they've got the ability to speak to people on a daily basis. The employer pays their wages. They can call meetings with the staff at any time to do that. It shouldn't prevent workers from having the opportunity of their ballot, their democratic ballot. And what we've seen with the British Airways dispute, what we've seen with the Network Rail dispute, and a whole host of different ballots, it's not about people voting yes or no. It's about purely bureaucracy to stop workers having the ability to defend their terms and conditions and their jobs.